Good morning, everyone, and thank you for joining us this morning. My name is Marty Rabinovitch. I am the head of the Employment Law Group here at Devry Smith Frank, and thank you for joining our seminar today on the new reality of COVID-19 advice and best practices for employers. So today's seminar will follow a slightly different format than our seminars normally do. I will speak about the topic for about 30 minutes this morning, and then afterwards I will answer as many of your questions as possible. So there is a space in the GoToWebinar software for you to type in questions. So if you have any questions about the coronavirus that you already have in mind, or if anything comes to mind throughout the presentation, feel free to type in a question as you go, and I will do my best to answer your questions in the Q&A period at the end. This program for lawyers is eligible for 1 substantive hour of CPD, and the program has also been approved by the HRPA. So for human resources professionals, it is eligible for 1 hour of CPD as well. So without further ado, let's get right into the topic here. So the next couple of slides are an overview of some of the questions that we're going to talk about today. There's a number of them. I'm not going to go through every question on this slide and on the next slide, but essentially, what do you need to think about now that we're in this new reality of COVID-19 as an employer? What sort of occupational health and safety concerns do you have to think about? If you are running your business and your employees need to meet with each other or with clients, what sorts of things should you be thinking about? If your employees are sick, need to go into quarantine, what are some of those issues, and how do we deal with that? Okay, so let's get right into it. So our first topic here is, well, what is this novel coronavirus? Okay. A lot of this may be familiar to you already. It's certainly been all over the news media in the last several weeks. It's a respiratory disease. It is very, very contagious. It can be spread through coughing or exhaling droplets of infected fluid. It can also be spread if there are droplets that land on surfaces that are then touched by someone else. And if you are standing, within 1 to 2 meters of someone, it's also or closer than that, it's also possible to catch it if you get coughed or sneezed on. What makes the novel coronavirus a little bit scary is that it has unfortunately killed a number of people worldwide already. There is no vaccine available for it right now, although clinical trials are ongoing. But realistically, if there is going to be a vaccine, it's probably not going to be ready for at least another 12 to 18 months. Most people seem to develop mild to moderate symptoms, which I guess is the good news, and many have no symptoms at all. Fear, cough, and shortness of breath seem to be the main symptoms. And if you are older, if you have an underlying medical condition, or if you have a weakened immune system, then you are considered at higher risk and would have a higher risk of death or severe complications if you are infected. So how do we prevent infection and transmission? Social distancing has become one of the catchphrases in the media these days. Who knew that in 2020, social distancing and flattening the curve, would enter our vocabulary. But in any event, it is recommended for people these days to maintain a distance of at least 2 meters between other people to significantly reduce your chance of getting infected by someone else. The Ontario government has now banned gatherings of more than 5 people, although there are some exceptions for families and whatnot. But this really does show how serious the virus is and how seriously the government is taking it. Staying at home as much as possible, even if you have no symptoms or you don't feel sick. What's also pretty alarming about this virus is that many people who are infected with it don't have any symptoms and don't even realize that they're sick or have it, but end up passing it on to others who then may display more severe symptoms. Washing your hands regularly, they say at least 20 seconds. Avoiding non-essential travel. In fact, our federal government is now recommending against any non-essential travel outside of Canada. Self-isolating for 14 days if you have symptoms or if you've had close contact with someone who has been infected with the virus, and certainly you want to stay away from anyone with symptoms or who has been infected. So what sorts of occupational health and safety concerns should employers keep in mind with respect to COVID-19? So under the Occupational Health and Safety Act, employers have an obligation to maintain a safe working place. And employees do have the right to refuse unsafe work. So employers in this new era really do need to take steps to ensure or to take as reasonable steps as possible to ensure that their working environments remain COVID-free. Because this virus spreads so rapidly, it's important for employers and employees to work together to ensure this. Now, employees with symptoms should be told that they have to advise their employer and not come to work. If that is not part of your company's coronavirus policy already, I'm assuming you are still operating, it should be. You don't want employees coming in with symptoms. For those employees who will not be able to come to work, I mean, there's always working from home options. We'll get into that a little bit later in this presentation. But as an employer, you should consider whether your employees may be eligible for paid sick leave under your policy, or if they are eligible for disability benefits, such as short-term disability or long-term disability. For those employers who do not offer any paid sick leave or any disability benefits, the employee could also apply for EI sickness benefits. So a worker would be eligible for those benefits if they're unable to work due to illness, injury, or quarantine now. So quarantine is the new part. That was not introduced until recently. So if the employee is required to, for example, self-isolate because they just got back, from abroad or anywhere really, the United States, and would be required now to self-isolate for 14 days, they would be eligible for 2 weeks of EI sick benefits. And normally there would be a 1 week waiting period, but the government has now agreed to waive that period if you are unable to work as an employee due to quarantine, and you are also not required to provide a medical certificate, and that is new as well. Okay. What could employers do, or what should employers do to ensure that they are acting in accordance with their obligations under health and safety legislation? There's a long list here. I won't go through every single item on the list, but in short, you want to keep your workplace clean. So often that will mean extra cleaning. It will probably mean shorter hours to give your employees who are working a bit of a break and to allow more time for cleaning. Your company may also want to consider policies in which visitors to the premises are limited, and if visitors really do need to come for essential meetings or for certain other essential functions, they should be screened to ensure that they don't have symptoms, and ideally should be told in advance that if they have symptoms, that they're not welcome on your premises. It's also helpful to make sure that employees are aware of what Canada Public Health is saying, and what the travel advisories are, for example. So at the beginning, as this pandemic progressed, originally the government was saying, well, you should self-isolate, if you come back from, certain coronavirus hotspots. Well, now what the government is saying is, well, if you come back to Canada from any foreign country, you are now required to self-isolate for 14 days. And if you don't, you're now in breach of a statute called the Quarantine Act, which will result in a maximum penalty of $750,000 fine and or 6 months of imprisonment. So the federal government is taking this very seriously as well. So we talked about this already, but you don't want any employees with symptoms in the workplace. So that should be communicated to employees in advance. If employees nevertheless are in the workplace and they are displaying symptoms like a dry cough and they're complaining of a fever, they should be immediately sent home, and they should be advised to seek medical advice either from their family physician or from Ontario Public Health. All right, meetings and events in this new world of COVID-19. So my first comment would be, really, where possible, in-person meetings should be avoided. And as employers, you should consider whether a face-to-face event can be replaced by a telephone conference or a meeting that's going to be held online, either by FaceTime, by Skype, by Zoom, or whatever it is. Okay, if for whatever reason a face-to-face meeting is absolutely required, you're going to want as few people as possible to be there in person. Tissues and hand sanitizer should be provided. Anyone who is supposed to be attending at that meeting should be reminded that if they feel sick or they have symptoms consistent with the novel coronavirus, they should not come. If you have to have people in the same room, they should be at least 2 meters apart. If despite all of that, someone develops symptoms or displays symptoms at the meeting, they should be told to leave and get appropriate medical advice. And then after the meeting, or really during, the employer should make a note of who was there in case it is revealed that one of the participants becomes a confirmed case of the coronavirus. And then you would want to tell others that they should be self-isolating for 14 days. Employees and traveling. So again, is the trip really necessary? So again, the federal government says that non-essential travel outside of Canada should be avoided. So probably this is not the time to be sending employees on international business trips. The government of Canada has also warned that if you leave the country, it may not be so easy for you at this time to get back. If someone absolutely has to travel, I would say you should not be sending any employees who are high risk, on trips. So the elderly or those with pre-existing conditions or compromised immune systems that really should not be going. Anyone traveling, should be washing their hands, social distancing, complying with the local authorities, and monitoring for symptoms when you get back. In particular, if you're in new coronavirus hotspots. Montreal apparently these days isn't doing so well. If someone returns from an area with reported COVID-19, well, if it's an international destination, they are now required to stay home and self-isolate. So if you are running a workplace where an employee could be working from home, that would be a good opportunity to have that employee set up to work from home. In particular, if they're self-isolating as a precaution, really, and they don't actually feel sick. And certainly, any employees, with symptoms, again, should not be allowed to be present in the workplace. This is an interesting issue about whether an employer can force an employee to wear protective devices, such as a mask or gloves or, eye protection. So right now, the issues that are coming up are really more about, certain workers saying that they're not protected enough. So, I mean, there have been some reports of nurses saying that, there is insufficient personal protective equipment available. So in a hospital, for example, there would certainly be some justification for a hospital to require, a doctor or a nurse to wear protective equipment. In an office, I'm not sure we're quite there yet. So it really depends on the nature of the workplace. I think it also depends on how the pandemic evolves and, whether we are successful as a province and as a country at flattening the curve. The situation changes almost hourly and daily. And I mean, there have been, some people out there who would argue that that members of the general public, at least when they're going to contained areas, such as a grocery store, should really be wearing masks because of how many people have been infected with this virus but don't display any symptoms. And the research has shown that masks can be effective at preventing the spread of COVID. So right now, in most workplaces, like offices and whatnot, we're probably, not quite there yet. But if the pandemic continues to worsen and the number of cases continues to grow exponentially, then employers, one day may, I would say, be entitled to say, look, everyone who's coming to work has to wear a mask and gloves, for example. All right, sick days are going to be an issue that are likely to come up a lot. So if an employee has to self-isolate or they feel sick, how do we deal with that? If there's no benefits available for paid sick leave through the employer, the answer is the employee should be applying for EI sick benefits. If there are sick leave benefits available through the employer, that's going to be one option. And I would just suggest to you as an employer, if you do offer paid sick leave, that if an employee says they need time off and they want to use their paid sick leave because of something that is coronavirus related, I would suggest to you as an employer that you interpret your own policy liberally and err on the side of paying the sick day for this particular absence. Or if your policy is too restrictive, it may be a good opportunity to amend it at least throughout the duration of this particular epidemic. This slide shows a list of a whole bunch of the leaves available to employees under the Employment Standards Act that may be applicable if they or someone in their family has been diagnosed with COVID-19. There are some new ones as well, and we will get to those a little bit later in this presentation, but the classic ones still may apply to employees in certain situations. This issue, this next issue here, is a common question that employers have asked me over the last couple of weeks. And the scenario is essentially this: an employee speaks up and says to an employer, I have this, fear of catching the coronavirus, so I just don't want to work. I don't really want to be in contact with anyone. So I don't want to come to work, and, can you pay me for all or part of this leave, or, am I entitled to EI? So the starting point here is that an employee does have a right to refuse unsafe work, and that is provided for in the Occupational Health and Safety Act. However, if an employee is going to enforce that right, they have to have a reasonable and credible explanation or assessment of their own risk. So if the employer comes back and says, okay, I hear you, but, we have implemented a social distancing policy, and, we have gloves available, and, we've moved your desk, so you're now in, an isolated part of your workplace. We're doing extra cleaning, there's hand sanitizer everywhere, and so on and so on and so on. And the employee says, okay, well, that's great, but, I still don't want to work. In that scenario, then it's possible for the employer and the employee to agree to an unpaid leave of absence. If the employer doesn't want to do that, and they have taken reasonable steps to make their workplace safe in light of COVID, and the employee still refuses to report to work, then that employee could be subjected to discipline, or, could be seen to have abandoned their job. This might be another scenario where exploring working from home options would come into play. So if your workplace is conducive to that, and, there is work that the employees could be doing from home, then that would possibly be another solution, in that regard. If an employee says, well, the reason why I don't want to work is because I'm considered high risk, because I have a compromised immune system, or because I'm over 60, that may very well be good enough, and the employer would probably not be able to discipline or terminate in that scenario. Another issue that, I'm expecting to see at some point is where we'll see employees who present medical notes saying that, they have some sort of stress or anxiety or mental health disorder, and that that combined with their fear of the novel coronavirus, and it makes them, it would make their condition worse if they were forced to work, and they present the employer with a medical note. So that's going to need to be dealt with a little bit differently. Probably there's going to be some duty to accommodate under human rights legislation that would be triggered there, and that's how the employer would need to deal with that. Another common question that has come up in my practice in the last couple of weeks from employers is, well, how can I reduce my personnel costs? So, in the coronavirus economy, some companies have shut down altogether, either because they are not considered essential businesses and were not included on Doug Ford's list of essential businesses in Ontario, and others have decided independently to close down for safety reasons, and others are working very few or limited hours just because, business is not so good. So the question is, well, how do we reduce personnel costs? So for starters, you can look at reducing your employees' work hours or their days of work. The potential problem, though, that you would run into as an employer there is you are likely in breach of your employment agreement with that employee, and depending on the amount of days or the amount of hours that are being reduced, you could actually be exposing your company to a constructive dismissal claim. So, so that those are the risks that go with that. One option that may be helpful for many employers is called work sharing. So essentially, the employees in question and the employer, would agree to an arrangement in which the hours of a particular position could be shared. So, for example, if a company normally has two administrative assistants that work from 9 until 5, but in this economy, the employer really only needs to have one assistant. Instead of firing one of them or laying off one of them, what you could do is you could have one of them work the morning shift, say, and the second one work the afternoon shift. Okay, and then if you file certain paperwork and register this work sharing agreement with Service Canada, then if you do it right, the employees would very likely be eligible to get a top up from EI. So that's a good way of reducing costs on the part of the employer, but at the same time keeping more employees working and at least earning something. The next point is temporary layoffs. So there are temporary layoff provisions which are set out in the Employment Standards Act at Section 56. So temporary layoff just meaning that you're going to tell your employee that, we don't need you, for the time being, and we'll let you know of your recall date, once we know. There's limits on how long the employee could be away from work. The catch, though, is that the way the law has developed is that there is no common law right to a temporary layoff. So what that really means is that unless you have a term in your employment contract which says, the employer may temporarily lay you off in accordance, with the Employment Standards Act, then you may not actually be allowed to do that, and the employee could come back at you and say, well, this is really a constructive dismissal or termination, and I want a severance package. Okay. Now, what I think remains to be seen, though, is whether the very, very unique times that we are in right now are going to change that. Everything is still uncertain. The courts have not yet weighed in specifically on this issue, but it is possible that the courts might say, yes, we know that the courts have not recognized this common law right to temporary layoffs, but given the very specific situation that we are in right now, we are prepared to recognize it. So that would not shock me if that happens, but we're still in a very uncertain age right now. Okay, there is a government wage subsidy. So this is a 75% wage subsidy for certain businesses for up to 3 months, and it's retroactive to March 15th of 2020. So that would certainly be something for an employer to look into. Employers are permitted to defer GST and HST remittances until June of 2020 now. There are some government guaranteed loans which are going to be available for small and medium-sized companies. And for those employers out there who pay into the WSIB, your premiums and reporting deferrals are till August 31st. So in other words, your premiums aren't due until August 31st. Okay, so that may help with cash flow issues. Oops. Okay, this is another issue that has come up in my practice. Can an employer implement a fever detection screening system? So in other words, are employers permitted to require employees to undergo temperature checks prior to permitting them to attend at the workplace? So at one point, at least, this is exactly what President Trump and his team were doing. So I'm not sure if he's still doing it, but at least for a time, his people were taking the temperature of any others who were going to be in close proximity to him. So I would say that if this is something that an employer wants to do to try and reduce the likelihood that someone infected with the novel coronavirus will be attending at work, I would say that you can do that. I would just suggest that, first of all, that you need to inform the employees well in advance if this is something that you want to do. The temperature checks should be conducted discreetly and confidentially, and everyone should be subjected to the check. If the employer is going to pick and choose, who is going to be subjected to a temperature check, that could be more problematic. In the non-unionized world, I would say this would probably be easier to implement and get upheld. In the non-unionized world, the employer is going to have more flexibility, but in the unionized world, it's going to depend a bit more on the collective agreement, and the employer in those circumstances may actually be a little bit more constrained. But it's not impossible. It could still be done, probably. And just, for employers out there who are thinking of doing something like this, I mean, of course, just be mindful that not all cases of the novel coronavirus present with high temperature as a symptom. So someone could still be infected and not have a high temperature. Okay, so keep that in mind. And the idea would be that if someone registers a temperature, that's considered high, I think the medical advice these days is, 37.8 or 38 degrees Celsius, the employee would be sent home. So as a practice, if this is something that you're thinking of doing, I would say, look, if they register with a high temperature and you're going to send them home, just pay them for the day to avoid disputes. But if notice was communicated to the employee in advance and the employee is refusing the temperature check, then the result in this scenario would be, well, sorry, you can't attend at our premises, you have to leave, and we're not paying you. Okay. If your workplace must be closed because of COVID-19, so, for example, if your company was not included on Doug Ford's list of essential businesses, you're going to be probably in a situation where you're either going to have to temporarily lay off employees or fire them, or at least agree to some sort of unpaid leave. So we talked a little bit about layoffs. In the unionized world, there usually are layoff provisions that are set out in the collective agreement, so those are going to govern. In the non-unionized world, it's we're looking at the employment contract. Are there temporary layoff provisions contained in the employment contract or not? And the uncertainty still being, well, if there's not, is the court going to permit these layoffs anyway one day, as long as they comply with the ESA, given the very, very unique situation in which we are faced now? Now, another interesting question that the courts will likely need to deal with at some point is what about non-essential businesses who are required to close by law, and whether frustration of contract would apply. So frustration of contract means that an intervening event that was not the fault of either party has happened, which has had the effect of substantially and radically altering the nature of the contract. So if I own a barber shop and I have 4 employees, and as I understand it, barbershops were not included on the list of essential businesses. And so now, as a barbershop owner, I am no longer legally permitted to operate. So the question would be, can I then tell my employees, look, I think the contract of employment has been frustrated, meaning that neither I nor you have any obligations under that contract. So you don't have to work for me, and I don't have to pay you, nor do I have to offer you severance. Whether frustration of contract is going to be applicable in this sort of scenario, I think really is going to depend on how long the state of emergency lasts for, and how long businesses such as barbershops are going to need to be closed. If things get better in a few weeks and we start getting back to normal, then I don't know, frustration may not fly. But if this situation goes on, for months and months and months, then the argument for frustration of contract, I think, would start to get better for an employer. Can an employer require an employee to use sick or vacation days if they're self-isolating? Generally, no. I mean, employers can schedule an employee's vacations in certain circumstances. Although, really, I think, when you're talking about paid sick leave or paid vacation days, an employee, I think, would be happy, to use some of them to ensure that their income is uninterrupted, or at least as uninterrupted as possible. So again, we have to look at whether or not there is going to be any entitlement to sick benefits, in a collective agreement or through the employment contract or policy. Now, if an employee is unable to work because of anything coronavirus related, the Employment Standards Amendment Act, Infectious Disease Emergencies, this statute came into force recently, and this is a job protected leave for employees who are unable to work for a number of reasons. And pretty much what it comes down to is if the employee is unable to work for something coronavirus related, such as they're under medical investigation, or they're self-isolating, they're quarantined, the employer says, you know what, you have to stay home. They have to take care of their kids because the schools have been closed now. This is a job protected leave for employees. It is an unpaid leave of absence, but it's a job protected leave. So in other words, you cannot fire an employee because they are not able to report to work because of something coronavirus related. Okay, and a list of what is included is set out here on this slide. All right, can employers require employees to disclose their specific COVID-19 diagnosis? So that's an interesting question, because typically in the employment law world and the human rights and accommodation world, we typically say, look, as an employer, you're entitled to the prognosis, but not the diagnosis, okay? And that comes from this case here called CEP Local and Hydro Agri Canada. However, the case also says that in unusual circumstances, an employee may be obligated to disclose their diagnosis. And again, keeping in mind that the situation is changing and the law is going to be uncertain because the courts have not yet had an opportunity to address these questions. But I'm going to suggest to you that, we are definitely in unusual circumstances right now. And I would say that, yes, an employer could certainly, require, an employee to disclose that they are infected with COVID-19, in particular, if they have attended work in the workplace and have been in close contact with other employees. So we're basically, this issue could be framed at some level in terms of, an occupational health and safety issue versus, a privacy issue. But, given, what we know about COVID-19 so far and how contagious and, how a lot of people have passed away as a result of becoming infected, I would say that the health and safety concerns are going to trump any potential employee concerns. Now, it doesn't necessarily mean that the employer has to post a bulletin saying, Mr. Smith has been diagnosed with COVID-19. You want to be, discreet about it and, the point is that anyone who may have been exposed, gets to self-isolate. So that's the important thing. You don't necessarily want to broadcast all over the workplace, who was infected. Okay. Can employers require employees to report their potential or actual COVID-19 exposure? I would say yes, and potential exposure is going to include close physical contact with an individual diagnosed with COVID-19 or travel to areas with an outbreak, which seems to be pretty much the whole world these days, unfortunately. If the employee is off work because of COVID-19 or self-isolation, are employers required to pay the employee? The short answer really is, well, no, unless there's paid sick leave pursuant to a contract or collective agreement that the employee would qualify. If an employee does display symptoms while they're at work, they should be sent home, and they should be told to contact their family doctor or Public Health Ontario for further advice. And in a scenario like that, I would say that it's a good practice just to pay the worker for the day, to avoid disputes. So what if an employee contracts COVID-19 at the workplace or develops anxiety or stress? If an employee is diagnosed with COVID-19 and the evidence suggests on a balance of probabilities that it was because of exposure at the workplace, now you're looking at a workplace injury, so that could make an employee eligible for WSIB benefits. And then the other WSIB benefit, which is interesting, is the chronic mental stress benefit. And that is something that an employee may be eligible for if there is stress and anxiety around potentially becoming infected with COVID-19. The employee has the burden of proof. They do have to show a diagnosis of anxiety or stress, and they have to show evidence that the cause of the mental stress arises out of and in the course of the employment. So there are pretty specific things that the employee would have to prove. Okay, and the last slide here before I get into the Q&A portion of this seminar is some tips on drafting COVID-19 workplace policies. So of course, we are happy to help with that if you need legal assistance with that. And if you haven't already implemented something, we are certainly happy to help you. Okay, so some things that a good COVID-19 workplace policy should include. It should be very clear, for employees in terms of who they should tell at the workplace if they have symptoms or if they're sick. I would say that your policy should require employees, certainly not to come to the workplace if they are sick, but if they are in the workplace and they see someone, who is, coughing nonstop, they should be required, I would say, to at least alert the employer, and the human resources department of your company will need to investigate that, or should investigate that. In this working from home age, this would be a good time to look at your company's working from home policy. Make sure that employees, in particular those who may have never worked from home before but who are now able to, are aware of what that policy includes. And if you don't have a policy or you need to update it, now would be the time. We also, it's also a good practice to ensure that employees sort of keep up to date with the advice of Public Health Ontario and Public Health Canada. You should remind employees that the employer's policies may change as the epidemic evolves. And I'll go through one more thing. Certainly, it should be very clear, for an employee who has been diagnosed with COVID-19, or if they have symptoms, what exactly the employer is going to require before they are permitted to return to work. So, for example, for someone who was diagnosed with COVID-19, you're going to want a medical certificate saying that you know, the employee is no longer. Thank you, everyone, for joining me this morning. For those of you whose questions I was not able to get to, please feel free to get in touch at my email address, marty.rabinovitch@devrylaw.ca or info@devrylaw.ca. Originally, there were going to be some other topics that were going to be included with this seminar. So when those slides are completed, they should be available on our website as well. Our next seminar is likely to be in 2 to 3 months. So stay tuned for that. So thank you again for joining us, everyone, and have a great day.